Well, tēnā koutou and welcome to the Social Issues Moot 2021 final. I'm Monique, one of the co-presidents of the University of Auckland Mooting Society, alongside Isabel. And I'd also like to introduce the other Monique, who's the president of the AUT Mooting Society. We hope that you and your whānau are all doing well despite being in level 4, and we're pleased to still be able to bring you this final from the safety of your own bubbles. As a bit of background, this moot is a collaboration between AUT and the University of Auckland, and it's only our second year running it. We've had great feedback from the moot last year, and we hope to see it develop in future years, along with this great mooting relationship between AUT and UOA. We would like to say a huge thank you to all the judges who have given up their time and offered their expertise. Moots are not possible without this generosity. And we'd also like to thank the College of Law for generously sponsoring this moot. Both mooting societies are grateful for the continued support from them. I'll now pass on to Isabel, who will introduce the bench and our finalists.
Tonight we have a formidable bench of judges to whom we are incredibly grateful. First, we have University of Auckland's Tracey Whare, who kindly wrote the problem for us. We have Judge Beck, who is an employment court judge, and Judge Armstrong, who has extensive experience in the Waitangi Tribunal and the Māori Land Court. Our finalists tonight are, for the appellants, Andrew Fu and Aria Zhang, and for the respondents, Isaac Lam and Ria Shon. Before we start the moot, we would like to pass to Tracey to say a few words about the significance of this moot problem.
Sorry, Tracey, you might need to unmute.
Kia ora. Tuatahi i ngā kai whakawā, Judge Armstrong rawa ko Judge Beck, he mihi mahana, tēnā korua kia tēnā korua. I ngā roia o te moot court, he mihi mahana kia koutou, tēnā koutou. Ki ngā kaimahi o te Mooting Society o te Waipapa Taumata Rau, tēnā koutou katoa. So, as already has been noted, I'm Tracey Whare. I'm a kaiako and lecturer at Auckland University, and I was asked by the committee to write the problem for this year's moot, which I gladly accepted. Very happy to be here. And just by way of background, the reason I chose this particular question, one, you will have seen that this is a very recent judgment, so it's a very topical issue, so I thought it was important to find an issue that was very current, which this is. Second, that it relates to a particular power that the Waitangi Tribunal has, which it has had very limited opportunity to exercise. So this is an important case for starting to develop some of the jurisprudence about what are the limits and the requirements of this resumptive power. Thirdly, I also thought it was an important case because it deals with some very relevant issues relating to Tikanga Māori. And as we can see, many of the court's decisions, particularly in the Supreme Court, are grappling with and addressing issues as to how state law and Tikanga Māori work together and or don't. So I thought it was important from that perspective. And finally, from a personal perspective, one of my iwi is Raukawa, which is one of the parties in this moot court. So I personally am very interested in the outcome of this case, and I'm quite familiar with the history of this as it relates to my community. So all the best to the mooters tonight. Kia ora.
Thank you so much, Tracey. All of our mooters really appreciate being able to moot such a topical and important issue in the New Zealand legal framework. So thank you again for that. Just a brief timeline of the evening. So we'll start the moot in like 2 minutes, and that should take approximately 1 hour till about 7:15, at which point the judges will leave and deliberate on the outcome, and that should take around 15 minutes. And once they come back and give their feedback, the moot should be over by around 7:45. So we will not be here too late. On that note, I now pass to the appellants.
Judge Armstrong, did you want to open
Yes.
the court?
Okay. Thank you, Judge Beck. Tēnei te mihi ake ki a koutou e tautoko ana i ngā mihi o tōku tungane ko kai whakawā whare. Tēnei te mihi ake ki a koe kōrua ko tōku tungane kai whakawā Beck. Ki a koutou ko taimai ki tēnei nohuanga o te kōti pīra, e ngā roia o te kai pīra, e ngā roia o te kai urupare hoki. Tēnei te mihi ake ki a koutou nau mai, haere mai. Kia ora everyone, and welcome to this sitting of the Moot Court of Appeal. Our judging panel has helpfully been introduced already, so I won't go through that, but we will ask for appearances from counsel.
Thank you, Your Honours. Tēnā koutou i te kai whakawā, ko Jang taku ingoa, e tū ana aho mō te kaipira I tēnei wā. May it please the court. Counsel's name is Jang and this is my junior counsel, Mr. Fu. We appear on behalf of the respondents, Ngāti Kahungunu ki Wairarapa Tāmaki Nui Arua Settlement Trust and Wairarapa Moana ki Powakani Incorporated.
Kia ora Ms. Zhang, kia ora Mr. Fu.
Your Honour, would you like us to proceed as well for the respondents?
Yes, please.
Okay. May it please the court, this is Mr. Lam appearing for the respondents, the Raukawa Settlement Trust, alongside Malone Jr., Ms. Sean.
Kia ora Mr. Lam, kia ora Ms. Sean. Thank you, counsel, for your appearances and also for the written submissions that you have filed. We have had the opportunity to read those and we're looking forward to having the opportunity to engage with you as you present your oral submissions. So we will start with the appellants.
Thank you, Your Honours. May it please the court. This is a case about an exercise of the Waitangi Tribunal's power in order to address the injustice suffered by the Wairarapa Māori. Today, I will be addressing the court on issues 1 and 2 in regards to judicial review and the tribunal's resumptive powers. And my junior, Mr. Fu, will address the court on the issue of tikanga. I will be making 2 submissions to the court today. Number 1, that there is insufficient basis to invoke the court's jurisdiction of judicial review. And number 2, that the tribunal's resumptive powers should be read broadly. Now, before I get into the substance of my submissions, Your Honours, would you like a summary of facts?
Ms. Zhang, we are aware of the facts in this case, so you won't need to repeat that for us. We would like to hear from you as to the arguments you wish to raise on appeal.
Thank you, Your Honour. Turning to my first submission, that there is insufficient basis to invoke the court's jurisdiction of judicial review. Your Honours, there is no doubt that the court has power to intervene via judicial review in the exercise of statutory powers such as the one the Waitangi Tribunal exercises. However, it is important to note that not all statutory powers are amenable to judicial review. Judicial review is a fundamental function of the court and should not be used lightly. And therefore, as identified in the case of Singh against Chief Executive, in these, should we say, ambiguous situations, what it really comes down to is whether or not there is sufficient basis for the court's jurisdiction to be invoked. Now, in the case of Singh, the court identified some factors that the bench may take into consideration. For example, the nature of the statutory power, the stage the proceedings has reached in the statutory process, and whether or not there are further opportunities for appeal and so on. But fundamentally, the approach they take is one that is contextual, that considers the circumstances of the case before they decide whether or not the court should intervene. And it is important to note that usually at a preliminary stage, the court is unlikely to intervene. And turning to the facts of this case, we submit that it is too early in the proceedings for the court to intervene via judicial review. We do note that the tribunal says that the inquiry has reached final stages, and Justice Cook from the High Court notes that it seems that they have reached some firm conclusions. However, yes, Your Honour.
Just before you proceed to apply the relevant facts in this case, I'm interested in the submission you have to make as to the approach that we have to take in considering whether the High Court should have conducted judicial review of a preliminary determination. So Justice Cook referred to several authorities which indicated that the High Court would only intervene in relation to a preliminary decision in exceptional circumstances where the decision maker had seriously gone off the rails. Justice Cook disagreed with that approach and considered that the proper approach is to weigh that up as part of the discretion that the court has in terms of whether to conduct the judicial review. What is the approach you say that we should take on appeal?
Your Honour, we agree in substance with Justice Cook's approach. We do not think that the case law requires an additional standard for circumstances to be exceptional before the courts can intervene. We accept that the court has discretion to intervene at preliminary stages. However, we do diverge from Justice Cook's approach when it comes to applying this approach to the facts. And the reason we say that is because we note specifically that the tribunal in its preliminary determination clarifies this determination is not an interim decision. So what that means for the statutory process is that if we look at the Treaty of Waitangi Act, the exercise of resumptive power is essentially a three-step process. So first, the tribunal makes an interim recommendation, and then there's a mandatory 90-day pause for the Crown and Māori to go away, negotiate settlements, and hopefully come to an agreement. And then step 3, only when there is no agreement reached does the interim recommendation then become binding, and then the resumptive powers are exercised that way. Whereas in this case, because the tribunal specifically clarifies this preliminary determination is not yet an interim recommendation, it means that we have not even yet reached the very first step in the statutory process of an exercise of resumptive powers. And we do agree with Justice Cook's approach to judicial review in substance, but to us, it seems that he has erred by failing to take this overall big picture into account. And that is why we submit that there should be insufficient basis for the court to invoke their jurisdiction on that matter. Furthermore, Your Honour, we would just like to briefly touch on the practical considerations Justice Cook mentions. And we say that practical considerations actually also support not intervening via judicial review at this stage. Even Justice Cook recognises that by entertaining a judicial review at this point could prolong the tribunal process and could also be unnecessary, since it seems very likely that a judicial review will be brought on the same facts at a later stage anyway. He dismisses these practical considerations by referring to the importance of the legal arguments that are being brought in this application. And we certainly don't dispute that there are important principles being discussed here. However, the function of a judicial review is not necessarily to clarify the law or to aid the tribunal in its decision-making process. Therefore, we submit that even though there are important legal arguments at this stage, Justice Cook did not take into consideration the highly specialised nature of Waitangi Tribunal as a body, and for that reason, practical considerations also support us not intervening via judicial review at this stage.
What do you say about Justice Cook's view that given the nature of these proceedings, that they are likely to move forward through an appeal process in any case, and that this was an exercise of power by the Waitangi Tribunal that they had not, I think there'd only been one occasion previously, and so that the tribunal itself could benefit from the clarification of the legal principles and its application to these particular facts at this early stage, as opposed to waiting and having it go through one appeal process and then potentially, I think his point is, going through another one. What do you say about that?
Your Honour, we don't dispute that this court can be of assistance to the Waitangi Tribunal by clarifying the law. However, the point of having such a highly specialised body such as the Waitangi Tribunal is so that they can exercise their expertise in these matters. And therefore, it is the appellant's view that it is better for the courts to provide that clarification and to provide that aid only after the tribunal has reached a finalised decision. Certainly not at the point where we haven't even reached an interim recommendation and all the determinations are only preliminary.
Ms. Jang, just following on from that answer and the question that Judge Beck has raised, because undoubtedly the Waitangi Tribunal is a specialist body and has specialist expertise, though their expertise is really in relation to inquiring into or factual inquiries as to whether there has been a breach of the principles of the treaty and applying the principles in terms of making recommendations to the Crown as to how it can conduct itself in a treaty compliant way. The exercise here in terms of resumptive orders is really a question of statutory interpretation. As Judge Beck has raised, this is a power that hasn't been used often, and a large part of the inquiry is around the nature and effect of the relevant legal provisions. And it could also be said that the High Court has particular expertise in statutory interpretation. So what do you say in relation to that, following on from Judge Beck's question, that the High Court can provide assistance on an issue that may fall within the High Court's expertise rather than particularly the Waitangi Tribunal's area of expertise?
Your Honour, like I mentioned to Judge Beck, we don't dispute that the High Court can provide assistance, but we do think that the tribunal, as that highly specialised body, is best placed to first consider their own resumptive powers in the context that they are required to exercise them in. And practically speaking, it is better for them to reach a finalised decision first before the court jumps in and say and provides a detailed feedback or any detailed clarification on that matter. In any case, regardless of whether your honours are with me on issue 1, I would like to now draw your attention to issue 2 of my submissions in regards to the resumptive powers specifically. And our submission on that is that the resumptive power provisions must be read broadly. And we would like to raise 3 reasons to support the submission. Number 1, the literal textual interpretation of the statutory language supports this reading. And number 2, the purpose of the resumptive powers would support this reading. And number 3, that there are further internal control mechanisms that can control the scope of the exercise of the resumptive powers. So starting with the first reason, this is one that is very well discussed in the tribunal's report. They specifically look at the statutory language, in particular, the phrase relates to, and they note that it is a very generic sort of use of language. And by using that language, they say, Parliament has chosen deliberately not to enact a more specific requirement for them to consider a land for the purpose of exercising resumptive powers. And the second reason we would like to raise, the purpose of the resumptive powers, actually support that reading as well. I do know the time, however, I would like to quickly diverge into the history of these statutory provisions and quickly touch on how resumptive powers came about. Initially, the tribunal did not have resumptive powers. They only had powers to make general recommendations. And it was only following the landmark cases of the lands case and the forest case that did the Parliament enact provisions to give the tribunal additional binding powers of these resumptive powers. And the reason they did that is to protect claimants. So the claimants before the tribunal didn't have to solely rely on good faith on behalf of the Crown. Essentially, resumptive powers are a product of compromise. On one hand, the government gets to transfer government-owned assets into private state-owned entities. And on the other hand, the tribunal gets the power to basically consider all of those lands and all of those assets where they deem fit to be returned to Māori ownership. So if we look at the purpose and how the resumptive powers actually came about, it seems clear to the appellants that the provisions at this point must be read broadly so the tribunal can properly consider all the lands and all the assets within their scope of their resumptive powers.
Ms. Zhang, just on the question you have raised as to the purpose of the legislation, and you've referred to the background which gave rise to these resumptive powers, and in particular the lands case. Now, if you put that in particular context, there was still a treaty settlement process available, which could involve the payment of money as compensation for prejudice suffered as a result of Crown treaty breach. Māori had a particular concern though, because lands were being transferred to other entities and the land itself may not be available as a form of relief for treaty settlement. So this effectively preserved the ability for those lands to still be available. But doesn't that reflect the significance of ancestral land to Māori? And is that the purpose of these resumptive provisions, to ensure that that ancestral connection can be maintained? And do we need to interpret the provisions within the Act, taking that into account?
Your Honour, I would like to raise a two-pronged response to your question, if you would allow me a bit more time. So
sure.
My first response to that, in addressing your concerns about the ancestral land and that connection, well, actually, under that point, I also have two small sub-points to make. First of all, this is so far, when we're talking about whether or not the scope of resumptive powers should cover this land, this is actually a very preliminary step. So first, the tribunal considers this land that is within the scope of resumptive powers, and then they move on to consider whether or not these lands should be returned, in fact. And I would submit that your concerns raised would be addressed by the tribunal in the exercise of their resumptive powers when they come to the step of considering whether or not the lands should be returned. And the second point I was going to raise is that this question and all your concerns actually relate very closely to my junior counsel's submission, and he will explain in more detail how the decision is consistent with tikanga and hopefully relay your concerns there.
Thank you.
And thank you, Your Honours. And I note the time, so if that is all, that concludes the appellant submissions on issues 1 and 2. And I will now give the floor over to my junior counsel, Mr. Fu.
Ms. Zhang, just before you leave, Judge Beck, Judge Whare, do you have any further questions for counsel?
No, thank you.
Well, thank you, Ms. Zhang, for the submissions you have made. Those would be most helpful. Mr. Fu.
May it please the court, the issue before us presently concerns the harm done to Waitangi Māori by the Crown over a significant period of time, and what redress can be given within the bounds of tikanga and under the principles of the Treaty of Waitangi. To this effect, we will be making submissions today on why the tribunal's recommendation to return the Pōkāni lands to Wairarapa Māori is consistent with both tikanga and the principles of the Treaty of Waitangi. To this effect, we will be advancing two primary submissions. Firstly, that the recommendation to return the Pōkāni lands to Wairarapa Māori is consistent with the requirements of tikanga in these circumstances. And secondly, the recommendation is also consistent with the principles of the treaty. Now, if there are no questions at this stage, Your Honours, may I speak to my first submission?
Yes.
Thank you, Your Honour. Now, with regards to the first submission, in respect to the point that the tribunal's recommendation to provide redress to Wairarapa Māori is consistent with what tikanga dictates is necessary in the circumstances, we wish to make two primary arguments. Firstly, that the recommendation to return the Pōkāni lands is consistent with the need to provide redress that tikanga dictates is necessary in the circumstances. And secondly, that provision of redress is also consistent with the principles of the treaty and the spirit of partnership that the treaty promotes. With regards to the first point, there are numerous concepts in tikanga that relate to the restoration of wellness and well-being after harm has been done. One of those is whakatika, the notion of making things right again. And another is utu, that idea of balance, of reciprocity and payment for harm. And when a hara, an offence or wrong, is committed, tikanga dictates that balance needs to be re-established. Now, the overall goal, as was pointed out by the tribunal, is to move towards a state of air which contemplates addressing not just the material harm inflicted on Māori, but also the emotional and spiritual damage that has been incurred. And that is really what is the heart of the case today.
Mr. Fu, sorry, Judge Beck, you go.
Mr. Fu, on your point of air, it seems to me that your argument is focusing very much on the wrong and redress for Wairarapa Māori. How can an order such as this achieve balance when arguably it is significantly harming another iwi and another group? And when you think about in particular, the community-based nature of tikanga, as opposed to focusing on the individual, what do you say about the fact that by arguably putting in balance for one group, you are significantly knocking out of balance the interests of another?
Oh, well, Your Honour, we would, if I might take that question in 2 points. Firstly, I gather you're referring to the mana whenua interests of Raukawa iwi. Now, the mana whenua interests of Raukawa iwi were considered at length by the tribunal.
I'm just going to interrupt you, Mr. Fu, not in particular their interests, but when you're talking about broad concepts like this, rather than getting into an argument about what the particular interests of the Raukawa iwi might be, I would like you to talk to me about the principles that you are wanting to apply of balance, when it seems to me that you're focusing only on balance in one particular area, as opposed to that more broader balance across the much broader community.
Certainly. Well, having regard to this broader notion of balance you refer to, Your Honour, this is very much a compromised situation. If we were to privilege the arguments of Raukawa iwi here, we would be left in a position where, on one hand, Wairarapa Māori will not obtain redress for the treaty breaches committed by the Crown over 160 odd years. But on the other hand, Raukawa iwi is in the same position it was before, because it cannot obtain legal title for Pōkāni lands as a result of its previous treaty settlement with the Crown. And in light of this latter point, the tribunal has made the decision to favour, in the interests of wider balance, to favour Wairarapa Māori in this case. They placed very heavy weight on the fact that Raukawa iwi have already had redress in their settlement with the Crown, and Wairarapa Māori have not. And they placed very heavy weight on the fact that Raukawa iwi can no longer obtain legal interest, legal title to the Pōkāni lands. And this...
So, just
Yes.
following on from what Judge Beck has raised and the response you have given, because I agree with you that tikanga requires there to be some form of remedy or relief for Wairarapa Māori for the injustices that they have suffered. But if you look at where that imbalance occurred between the Crown and Ngāti Kahungunu, or the Wairarapa Māori, as they're also referred to at Pauakani. So in terms of restoring the balance between those two, can the Crown not provide relief to Ngāti Kahungunu by way of payment of money, or by the return of land within Ngāti Kahungunu's traditional rohe? Won't that provide restoration, meet those principles of whakatika and utu, but won't require ancestral land from another iwi to be returned to Wairarapa Māori?
Certainly, Your Honour, it would be ideal for all parties in these circumstances if it were open for lands in Wairarapa Māori traditional rohe to be returned to them. However, as I understand that the tribunal is considered the paramount expert body on tikanga in this situation, and were it open to them to do so, to find a solution that had regard and could fulfill the tikanga interests of all party in this situation, I'm sure they would have done so. But as they have pointed out, we live in a tikanga compromised world. This is a post-colonial New Zealand where Māori have experienced, along with the fracturing of their traditional tribal society, immense dislocation. Although the case of Takamore and Clark concerned an entirely different subject matter, that spirit of the realities of modern New Zealand and the conflict with tikanga and traditional Māori values is similar to the case here. And in Takamore and Clark, the court pointed out that there will be inevitable conflict between those tikanga values and the realities of modern New Zealand. And I think this is what we're seeing here. The compromise here certainly is uncomfortable, and in the context of this legal dispute, it certainly isn't ideal. But I would emphasize to your honours again, in light of the need to provide redress to Wairarapa Māori on one hand, and in respect of the fact that firstly, Raukawa iwi cannot obtain legal title to the Pōkāni lands, and secondly, that they have not occupied the Pōkāni lands in accordance with tikanga for some time, the tribunal has effectively delivered the best outcome it can under highly compromised circumstances of a post-colonial New Zealand.
On that particular point, in terms of impact on Raukawa and Tuwharetoa, it's certainly clear that they have settled, they have had full and final settlements, and so they cannot receive these lands. Isn't there still an impact on them under tikanga, though, of returning what was once their traditional lands to another iwi? Doesn't that still undermine tikanga principles of mana whenua, rangatiratanga, and kaitiakitanga? And aren't those relevant factors in terms of whether the tribunal has acted consistently with tikanga when ordering resumption of these lands in favour of Wairarapa Māori?
Your Honour, we would advance 3 points in response to that. Firstly, this determination, this return of land to Wairarapa Māori does not displace Rokawa iwi as tangata whenua of the Pōkani lands. Wairarapa Māori will forever be interlopers, visitors on those lands as Pākehā are. Secondly, I would just raise the point again of the fact that Rokawa iwi have not occupied those lands in accordance with tikanga for a significant period of time. And thirdly, the tribunal has suggested in its determination, and we would submit that this is the sensible thing to do, that the mana whenua concerns and the rangatiratanga concerns of Rokawa iwi might best be addressed in the constitution of the recipient entity of these lands, that the lands will be vested in at the end of this process. And I believe Rokawa iwi have already made suggestions to this effect. The constitution of this body, I believe, is a matter to be taken up at a later iterative stage of this process.
Thank you, Mr. Fu. Judge Beck, Judge Whare, do you have further questions for Mr. Fu?
Not me.
I think many of the questions that I had planned to pose have been put to Council. But just to pick up on one of the points you mentioned about how it's the tribunal cannot have the land returned to mana whenua, I'd still like you to elaborate a little on how that, even if that's not the case, Rokawa continue to have a relationship with that land as mana whenua, and it would seem that the exercise of this resumptive power would sever even more so the ability to have that relationship. I wanted to hear Council's views on that as part of that elaboration and understanding of Tikanga Māori.
Firstly, Your Honour, we'd like to again advance 2 points on the matter. Firstly, the proposed vesting of these lands in Wairarapa Māori concerns the transfer of legal title which, one, Rokawa iwi cannot obtain, and two, does not and cannot displace their status as tangata whenua of the lands. And the second point in relation to this we'd advance is that even given the prospect of Wairarapa Māori obtaining legal ownership of these lands, it would be entirely open for the parties to come together after the process, for instance, most pertinently on the constitution of an appropriate recipient entity that might have regard for the tikanga concerns of both parties, and particularly Rokawa iwi. And the tribunal states that it hopes to see the parties come together in this process over the constitution of an appropriate recipient entity to change the dynamics of the relationships at the Pōkani lands. And I think this is an entirely necessary process, given the fact that most Māori have been tremendously dislocated from their tribal homelands, that we live in the post-colonial reality of modern New Zealand, where at the turn of the 21st century, only 4.5% of land in the country was owned by Māori. I think this is an entirely necessary and practical step having regard to tikanga that needs to be taken in the circumstances. Now, in the interests of time, Your Honours, I would just like a couple of minutes to quickly touch on mana concerns and also the principles of the Treaty of Waitangi and what they entail in the circumstances. Now, having regard to mana, obviously the severance of Wairarapa Māori from their ancestral homelands has diminished the ancestral connection to those lands, their tangata whenua status, and thereby their mana, and the provision of redress by the Crown would certainly go some way to helping restore their mana, as well as the mana of the Crown, which has been diminished by the hara they have committed. And finally, on the principles of the Treaty of Waitangi, as was pointed out by the court in New Zealand Māori Council and Attorney General, the overriding spirit of the treaty is one of a continuing developing partnership between Crown and Māori. And if Wairarapa Māori are to be equal partners in this treaty, if there is to be indeed a continuing relationship, a fruitful continuing relationship between Wairarapa Māori and the Crown in the future, then giving them the capacity to rebuild from their state of landlessness with the Pōkāni lands would surely be a sensible step. And I think the tribunal summed it up very nicely when they said that Wairarapa Māori cannot share in the benefits of settlement as an equal treaty partner until they have a stake in modern New Zealand society. And I think the provision of the Pōkāni lands certainly provides them with such a stake.
Mr. Fu, just on that issue, in terms of whether the decision of the tribunal is consistent with the principles of the treaty, now again, you have rightly identified the principles of the treaty concerning the relationship between the Crown and Wairarapa Māori. Isn't the difficulty here that the Crown owes obligations under the treaty not only to Wairarapa Māori, they also owe obligations to Raukawa and also to Tūwhare Toa. And doesn't the Crown have to actively protect their interests? And if the tribunal is ordering the Crown to return this land to someone who doesn't fall within the whakapapa of those iwi, isn't the tribunal requiring the Crown to create a further grievance for both Raukawa and Tūwhare Toa?
Certainly. Well, Your Honour, there, I'm afraid, is no simple answer to this question. On the one hand, as you rightly said, the vesting of Pōkāni lands in Wairarapa Māori may very possibly give rise to fresh grievances on the part of Raukawa iwi. But on the other hand, to leave Wairarapa Māori's injustices without redress, and again, I would emphasize to you, Your Honours, again, Raukawa iwi have already had settlement with the Crown. To leave Wairarapa Māori without redress for the harm they've suffered for the past 160 years, again, is continuing the cycle of harm, the cycle of treaty breach that has been perpetuated by the Crown. And as uncomfortable as this solution is in the circumstances, the cycle has to be broken at some point. And with
Mr. Fu, doesn't this raise the question I had earlier that the Crown certainly needs to provide redress to Wairarapa Māori, but it doesn't need to provide this land as redress, that it could do so through other forms, which won't offend against Raukawa and Tūwhare Toa, and so will therefore be treaty compliant in relation to all of those iwi?
Certainly, and if I may answer that with 2 points, Your Honour. Firstly, the provision of land to Wairarapa Māori, who through the Crown's treaty breaches have been rendered, as the tribunals recognised, essentially landless, is important not just for the purposes of tikanga, to restore their mana, but also to engender a capacity to rebuild that is so essential to them being able to take up their positions as equal partners in the treaty with the Crown. And again, I'd emphasize to Your Honours the tribunal's statement that Wairarapa Māori cannot be equal partners if they cannot share in the benefits of settlement. And the second point, Your Honour, with regards to an alternative remedy that does not impact interests of the Raukawa iwi and Tūwhare Toa, having regard to the tribunal's position as the paramount expert on Māori affairs and tikanga and the circumstances, as Justice Cook mentioned in the court below, despite his finding against the tribunal's determination, it would take a far braver man than I to say that I could suggest a remedy more suitable than the tribunal's.
Thank you, Mr. Fu. Judge Beck, Judge Whare, do you have further questions for Mr. Fu?
No more from me, thank you. Thank you, Mr. Fu.
No
If
further
that
questions
pleases-
from me.
If that pleases the court, those are the submissions for the appellant.
Thank you.
Thank you, Mr. Fu. That was very helpful. Mr. Lamb, we will now hear from you.
Thank you, Your Honor. Can I just get a mic check? Can you hear me loud and clear?
Yes.
Great, thanks. Right, so may it please the court. As beautiful as we know our country to be today, the reality is that Aotearoa, New Zealand has a dirty colonial past. Following the arrival of Pākehā settlers in the early 1800s and the questionable signing of the Treaty of Waitangi in 1840, countless grievances have been since committed against Maori and their iwi by the Crown. And this is the context under which the Waitangi Tribunal was established, empowered by the Treaty of Waitangi Act in 1975 to, I quote, inquire and make recommendations upon historical treaty claims. It was intended to empower the place of treaty principles within our contemporary legal framework. And one such claim is the subject of our hearing today, in which the issue cuts to the core of the tribunal's purpose. It needs to be answered. If the tribunal is supposed to empower treaty principles, should we just stand by and let it make orders that disregard core Tikanga principles about native connections to land? And so for this reason, we seek the court to allow a judicial review of the preliminary decision in the tribunal. Under the first issue of whether the decision should be judicially reviewable, I would submit that there is authority permitting judicial review of preliminary decisions, and that both the common law and policy considerations support permitting it in this case. And under the second issue of what the scope of the tribunal's resumption powers are, I will submit that statutory authority suggests that resumption can only be ordered to parties with traditional connections consistent with Tikanga to the land in question. And Junior Counsel Ms. Sean will then proceed to discuss the third issue of what this requirement substantively entails in the tribunal's decision-making. So at this point, are there any questions, Your Honors, before I proceed to the first issue? We good? Okay, I will begin on the first issue now then. So on to the first issue of whether judicial review should be permitted. My first submission mainly concerns the relevant statutory authority that's been pointed out by opposing counsel earlier. Section 11 of the Judicial Review Procedure Act 2016 provides that proposed exercises of statutory power can be subject to judicial review. And as noted also by opposing counsel, the common law has affirmed that the courts need a sufficient basis to justify exercising this power. And what this basis is was recently considered by the Court of Appeal in the case of Singh and Chief Executive of Business, Innovation and Employment, in which they proposed mainly four relevant criteria. I will henceforth refer to this as the material influence standard, as Justice Renderson did in paragraph 40 of the case. So this leads me mainly to my second submission in paragraph 3, that judicial review should be allowed because the tribunal's preliminary decision, as it stands, will materially influence the final decision. So we submit that determining when a preliminary decision can qualify as a proposed exercise of statutory powers should involve testing the facts mainly on 4 components that I have listed out in my submissions. I think point 3.3. We do not agree that this test should be broadly contextual as opposing counsel has earlier submitted, as we believe the courts would not have set out such a strict list of criteria had that been the case. So once again, returning to the criteria, they are firstly the nature of the power being exercised, second, the stage of the relevant statutory process things are at, third, the likely influence the exercise would have in the ultimate decision, and 4, whether there are further opportunities to correct potential errors like a right to appeal. I will now go over these components with reference to the facts in order. So very quickly on the first point of the nature of the power, it is conferred through Section 8A. Yes, Your Honor?
Just before you go through and apply those principles here, I'm just interested in your response as to how we treat those principles, because you referred to them as being rather strict criteria that have to be applied. Ms. Zhang made the submission that the court has a broad discretion when conducting judicial review, and that the court's discretion is not limited. It has to weigh up the relevant circumstances of the case when deciding whether it should exercise its powers. So what do you say as to that alternative approach submitted by Ms. Zhang?
I do note opposing counsel's submission and do believe it is grounded in, I believe, Justice Randerson's claim in the same case that this list is non-exhaustive and not a closed list of criteria in any way, that it needs to be applied, of course, with reference to broader considerations. But I also, once again, would like to submit that had these criteria been intended to be taken perhaps lightly in the sense that we should not look to them first before considering other scenarios, I do not believe that in that case, we would have such a neat list of criteria listed. So I believe we would do well to first consider them and perhaps subsequently afterwards only then decide if perhaps we need to consider other broader considerations. That's my main submission on that point, Your Honor.
Thank you.
Thank you. So returning back to the first point rather, on the nature of the power, Section 8A of the Treaty of Waitangi Act 1975. This point is usually about the statutory power part of the Section 11 requirements, so I do not believe it needs to be explained too much, but as I will come back to later, this is a really important point in this case. And on the second point of the stage of the process, now this appears to be quite late into the tribunal's inquiry, as noted by Justice Cook. The tribunal has conducted at this point 105 pages of complex legal analysis of the relevant legal questions, and its conclusions appear satisfied that all the relevant legal questions have at least been addressed. Justice Cook in the High Court cites paragraph 215 of the preliminary report, which I will not quote here in the interest of time. It's quite a long one. And I would like to note that it is true, as opposing counsel noted, that the tribunal has written a few disclaimers emphasizing that things could change in the final decision. However, as Justice Cook also pointed out, we submit that this is not reflected substantially, particularly on the most relevant matters in this appeal concerning the respondents' competing claims to Pukani lands. For reference, I would like to submit paragraphs 258 and 259 of the report, which are way too long for me to quote here as well. But I would like to point out that these are not, it would be inappropriate to quote one or two sentences of these sections out of context in this case as evidence, as this requires us to consider the tribunal's analysis in whole. And moving on to the third point on the likely influence the exercise would have in the final decision, we submit that this is very likely. It is important in this case that the body, the tribunal, issuing the preliminary decision is the same body that will exercise the consequent statutory powers. And the tribunal states in paragraph 17 that their preliminary decision is intended to help the assessment of, quote, operational implications. And these are strong indications that this preliminary decision is therefore not just indicative, but also informative.
Mr.
Yes, Your Honor.
Lamb, you've acknowledged that there are aspects of the decision of the tribunal that have made it very clear that they haven't yet made a final decision. Given the nature of the tribunal, and in particular the specialist nature of the tribunal, and the way in which its process is very iterative, involving the parties throughout the process to make submissions and not make final decisions early, but have preliminary determinations. I mean, the purpose of this one here is to invite submission. Wouldn't these submissions that you're now making to us be better made to them and allow that tribunal that has this enormous expertise and incredible knowledge and processes sitting in behind it to actually take into account the submissions that you're now making and have the opportunity to revisit what is only a preliminary view, as opposed to us now imposing our decision making on in an area that is not our specialist expertise.
Thank you, Your Honor. So I believe in your points there are 2 points I need to address. Firstly, that the tribunal's specialist authority, and secondly, the possibility that we should be speaking perhaps to them directly to kind of deal with the decision being proposed. So on the first point, I would like to revisit my first point earlier, actually, that the authority that the tribunal is exercising in this case is in fact empowered specifically by through statute, Section 8A of the Treaty of Waitangi Act. And I do believe that provides the grounds for, that provides a strong case to permit judicial review in the sense that they are not exercising necessarily this discretion that is entirely specialist, but rather constrained tightly by statutes that were written specifically to empower them. And on the second point, which is the possibility of consulting them directly. I think I would actually prefer to touch on this in my next point if possible, because this concerns the fact that there is no formal appeal process available at this stage through the tribunal, that the preliminary decision is almost as good as set in that case. And considering that, would you mind if I proceed to that, or?
Well, that's up to you, but what I'm putting to you is that their decision is not set in this case, and they've made that clear. So isn't it better to use the systems and processes that the tribunal have to raise these issues, rather than spending time and using up time on an appeal both to the High Court and, well, a review through the Courts of General Jurisdiction?
Your Honor, my submission is that there actually is no sufficient process available to the respondents to actually challenge the tribunal on that claim, as although opposing counsel did note that this decision is preliminary, and that means there's this 90-day period for parties involved to kind of grapple with what they're faced with and what their options are. There is no option through statute for the parties involved to take up their grievances with the tribunal directly. That 90-day period is intended only for parties to settle amongst themselves and decide what perhaps they might want to do amongst themselves. There is no mechanism for parties to take their grievances to the tribunal beyond a judicial review of the final decision, which I believe I submit in this case is not really the most practical way of going about it, because either way, that is going to prolong the case for the same amount of time. Does that answer your question, Your Honor? Yes, Your Honor?
Mr. Fu, I'll just follow on from that submission and picking up on what Judge Beck has raised, because you have said that waiting for the final decision won't make it any more efficient. But here we have a preliminary decision. There has been judicial review by the High Court. That decision has now been appealed here to the Court of Appeal. It may well then be appealed from here to the Supreme Court, given the significance of the issues that we are dealing with. After that, the tribunal will then have to go back and make a final decision. It is highly likely that there will then be a further application for judicial review against the final decision, and then appeals again to the Court of Appeal and the Supreme Court. So by conducting a judicial review of the preliminary decision, aren't all parties having to go through this process twice? Whereas if the tribunal proceeds to make a final decision, it is only going to have to go through that process once on the complete decision.
Well, in response to that, Your Honor, we are certainly making these submissions contingent on the assumption that we are submitting for judicial review because we submit that there has been an error in the tribunal's judgment, in this case in the preliminary decision. And we are certainly submitting this contingent on the assumption that should this error be raised through this preliminary review, that the tribunal will correct it, and consequently there should not be a further need for judicial review should this error be corrected. Does that answer your question, Your Honor?
Yes, but in a case that is highly contested such as this, if the tribunal grants an order requiring resumption, Raukawa and Tūwharetoa are likely going to challenge that decision through whatever means they can because of the significant impact on them. If the tribunal declines to grant a resumptive order, Waitangi Māori are likely going to take up a challenge because of the significant impact on them. So it seems that that process is inevitable in a case like this. Doesn't that indicate that it's better to wait for the process to complete before the tribunal so that parties are not going through a judicial review and appeal process twice?
That is certainly, I do agree that that's a fair point, Your Honor. But at the same time, I do believe that it is also within the scope of what judicial review seeks to achieve, which is ensuring that the different branches of power, of course, are regulated appropriately. That since there is an issue present in the preliminary decision right here, that it is appropriate to order review of these issues as they emerge, and not that we shouldn't overlook them entirely and perhaps slack on that policy consideration behind judicial review, simply in the interest of practicality, as these issues need to be addressed as they appear. In the interest of time, I think I will just move on mainly to the second issue at this point, because my third submission, I think, is quite clearly addressed in my written submission. So if there are any questions, Your Honours, on that? Okay,
Thank you.
Yeah. So mainly the second issue, going back to what Section 8A of the Treaty of Waitangi actually requires. So my main submission under this issue at paragraph 6 is that the relationship Section 8A specifies must be consistent with the principles of the treaty and therefore by extension, Tikanga. And that the tribunal, I would like to note that the tribunal does not have free discretion in exercising their resumption power, as it is empowered directly from statute. Parliament would not have set up such closed or exhaustive requirements in Section 8A had they intended that to be a broad discretionary power. Opposing counsel was therefore correct in turning to the Interpretation Act, which calls for us to interpret the term in light of its purpose, and thus turn to the statutory history of these provisions as discussed in Haronga. However, we also need to remember that Section 5, subsection 2 of the Interpretation Act calls us to consider indications of purpose within the enactment. And to this end, I would like to draw attention to the purpose of the tribunal as stated in the preamble to determine whether matters are inconsistent with treaty principles. I submit that Chief Justice Elias and Justice McGrath's statements in the Haronga case therefore need to be read in the light of this purpose. So if the 1988 amendment's purpose was to empower the tribunal to protect claimants, it stands to reason that a secondary purpose of the amendment is to ensure that treaty principles are empowered. This counsel suggests that the provision should be read narrowly to require connection to the land that is coherent with treaty principles, because the context and purpose ultimately highlight the Act's social justice core, that it acknowledges and aims to correct historical treaty breaches that disregarded Maori Tino Rangatiratanga and the place of Tikanga. All its provisions therefore should be interpreted through a Tikanga lens as legislation that aims to empower the legal position of Tikanga and treaty principles. I believe that is all I stand to submit at this point, mainly that the purpose and the context of the Empowering Act is support a narrow reading that connection with Tikanga and treaty principles is necessary. My junior counsel will address what that actually entails substantively, but at this point, are there any questions, Your Honours?
Judge Beck, Judge Whare, do you have further questions for Mr. Lam?
Thank you.
Okay, that's all from me then. I'll hand over to junior counsel now. Thank you, Your Honours.
Thank you, Mr. Lam.
Sorry, to unmute. May it please the court, I'm appearing for the respondents in this case and will be considering the third issue you raised, that concerning Tikanga and the principles of the Treaty of Waitangi. I will first outline the Waitangi Tribunal's exclusive jurisdiction to make recommendations on treaty claims. I will then go on to discuss why the Waitangi Tribunal's decision is inconsistent with the principles of the treaty and Tikanga Māori and is therefore unlawful. Finally, I will submit that the decision of the tribunal involves a further contemporary breach of the treaty. As I make my submissions today, it is important to remember that the Treaty of Waitangi was effected with the promise to protect Māori culture and property. Your Honours, I will now begin my first submission. Although there are inconsistencies between the Māori and English translations of the treaty, the importance of creating good faith relationships prevails. And while there are limits on the extent to which treaty rights can be argued and enforced in court, the Waitangi Tribunal has exclusive jurisdiction to make recommendations to the Crown in accordance with the principles of the treaty. The Tribunal's main role is to see history through the lens of the treaty and its principles, and remedy historical injustices done to Māori through Raupatu, as well as address contemporary issues. Because of its exclusive jurisdiction, it is paramount that the tribunal is held to the same high standards of the Crown. And as the English and Māori translations of the treaty are not consistent, the principles of the treaty are drawn from both texts. Article 2 of Te Tiriti o Waitangi guarantees Te Tino Rangatiratanga of Māori, chief authority over lands and other taonga. This naturally includes the tikanga and customs associated with the lands. Your Honours, if there are no questions, I will move on to my second submission.
I do have a question, but it may relate more to your second submission, but I will raise it now because it touches on the first part of the submission you have made. So you have referred to the expertise of the Waitangi Tribunal in these particular issues, and you have said that that creates a higher obligation on them to also comply with those principles. In addition to the general expertise, the specific tribunal panel that heard and made the decision on this application is also relevant. We have a Māori Land Court judge from a special jurisdictions court who regularly deal with tikanga. We also have Dr. Rua Kirehond, who's a renowned kaumātua academic and is an expert in both the Māori language and tikanga. And we also have Dame Margaret Basley, who's a very experienced public servant. So both the jurisdiction generally and this panel particularly has significant expertise in tikanga Māori. Taking that into account, is it appropriate for a general jurisdiction such as the High Court to make findings that the Waitangi Tribunal has acted inconsistently with the principles of the treaty?
I agree with Your Honour completely that the tribunal is an expert body and that the panel members also have a very high level of expertise. What we are submitting today is not that the tribunal erred in what constitutes tikanga, but as in my second submission, that they did not consider the tikanga aspects correctly of both parties that we're representing here, are being represented here today. So in summary, that they have not correctly applied tikanga. I will now move on to my second submission to address that further.
Thank you.
The proposed granting of the Polokani lands to iwi with no ancestral connection to the land is inconsistent with tikanga and the treaty principles of good faith. Tikanga is used to describe Māori customary practices and behaviours and is increasingly recognised in the New Zealand common law. In their preliminary decision, the tribunal acknowledged that there were tikanga considerations to be made, as Wairarapa Māori are not tangata whenua of the Polokani lands. However, they went on to say that they were not influenced by tangata whenua considerations, as occupancy by Ngāti Raukawa had long been in abeyance. In their decision, the tribunal said that a transfer of ownership of the lands at Polokani would not give Wairarapa Māori the status of tangata whenua, but instead they would be like Pākehā landowners in the district. This likening to Pākehā ownership emphasises the lack of connection that Wairarapa Māori have to the land. The tribunal is willing to grant ownership status to a group that they consider equivalent to Pākehā landowners. However, when you consider treaty settlement conditions, such as the right of first refusal, they should be more hesitant in doing this. Such considerations often given in settlements emphasise the recognition that the government and tribunal usually give to Māori people's deep connection to their ancestral land. My learned friend on the opposing council submits that there is a need to provide redress consistent with tikanga, the wrongs done to Wairarapa Māori in the trade of the Wairarapa Lakes. I wholeheartedly agree with this. However, this requirement for redress is not all that needs to be considered. The tribunal held a wānanga with experts on the tikanga of redress with the goal of discussing restoration and correcting wrongs. However, this wānanga only considered the importance of redress to Wairarapa Māori and not the effects of this particular route of redress on Ngāti Raukawa, the traditional guardians of the Polokani lands. I disagree that the land to be given as redress should be the Polokani lands. We do not submit that Wairarapa Māori should receive no land, but that the tribunal did not reach a conclusion consistent with tikanga and the principles of the treaty in recommending the grant of lands in Ngāti Raukawa's traditional rohe. Where this land be located or what settlement Wairarapa Māori should receive is a judgment for the tribunal to make consistently with tikanga and the principles of the treaty. And as I mentioned previously, and as I will go on to discuss, this is what they have failed to do here. Despite their obligations to empower the legal position of tikanga, the tribunal claimed the situation is sui generis and they were exercising judgment in a tikanga compromised world. However, as Professor Ruru says in her affidavit, there is no such thing as compromised tikanga. And to quote Professor Ruru, if settler legal systems wish to realise aspirations for legal reconciliation with Indigenous peoples, then an important component of this is to recognise Indigenous peoples. If the tribunal is allowed to decide which groups' feelings are worth recognising, it would not be consistent with what the tribunal is empowered to do. It is, however, empowered to consider and uphold the tikanga of all groups. This will lead on to my third submission, that the decision of the Waitangi Tribunal involves a further contemporary treaty breach. If Your Honours have no questions, I'll move on. No?
Perhaps, yes, move on, Michonne. I do have some further questions, but you complete your final submission, then perhaps I'll come back to it.
Okay, thank you. So the land that the Waitangi Tribunal recommends the Crown grant to Wairarapa Māori was not in their traditional rohe, but that of Ngāti Raukawa and Ngāti Tuparetoa. Transferring ownership of the land that is so strongly connected to one iwi group to another that has none would create overlapping mana whenua claims. This creation of further discontent is undoubtedly contrary to the objectives of the Treaty of Waitangi and to its principles. Such historical contexts of land should be considered in great depth by the Waitangi Tribunal when making recommendations and cannot be ignored. In the Wairarapa report, the Tribunal found the Crown purchase of Māori land in the 19th century occurred too quickly, and these purchases gave more weight to the interests of Pākehā settlers than that of tangata whenua. This brought decades of conflict for Wairarapa. The Tribunal reported that the failure of the treaty to protect from this was a breach of the principles of the Treaty of Waitangi, in particular, those of partnership, good faith, and active protection. In the Wairarapa report, they urged that Māori rights in and around Wairarapa Moana be recognised and given effect. However, this same recognition is not being given to Ngāti Raukawa's position. Creating overlapping mana whenua claims and tension between iwi groups is not consistent with the principles of the treaty and creates a new breach similar to that between settlers and iwi. The present recommendation does not appropriately give effect to these principles of partnership, good faith, and active protection. A determination creating a new breach is inconsistent with the tribunal's statutory powers. The tribunal's authority is statutorily conferred through the Treaty of Waitangi Act 1975. As discussed by my senior counsel, all points suggest that the tribunal is empowered with the intention of affirming the principles of the treaty and tikanga, and therefore it should act in a way that does so. The tribunal creating a breach would be particularly egregious because it is empowered to help right the wrongs done by the Crown by making recommendations. And these wrongs included the taking of land from iwi through questionable means such as confiscation, dodgy sales, and legislative measures. The creation of a new breach goes against the purpose for which the tribunal was created. It is up to the tribunal to consider the tikanga interests of both Ngāti Raukawa and Wairarapa Māori in making a settlement. Your Honours, I would like to address some submissions made by opposing counsel, but if you would like to ask your questions now, I'm very open to them.
Perhaps I will start with a question I have, Michonne, because it relates to both the submission you have just made and the earlier submission. And that concerns the impact of the order on Ngāti Raukawa and Tuwharetoa. Because as you have rightly pointed out, they are the tangata whenua of the rohe, and they have mana whenua there. You have also referred to the statement by the tribunal that Ngāti Kahungunu or Wairarapa Māori are not tangata whenua, and they never will be. Now, if we look at that statement, it seems that what the tribunal is saying is that the return of these lands to Wairarapa Māori will not make them tangata whenua, and therefore the tangata whenua status of both Raukawa and Tuwharetoa are preserved. And so there is no further grievance impacting upon their status as tangata whenua. What do you say in response to that?
Your Honour, I would say that I do agree, yes. The tribunal has said that they would not be tangata whenua. However, and the fact that the land has not been in Ngāti Raukawa's position for an extended period of time means that their position will not change regardless of who the land is granted to. That is what you're saying, is that correct?
Yes, and my question is, does that preserve the tangata whenua status of Raukawa and Tūwharetoa and thereby mitigate against any impact on them?
I believe that the fact that the land was taken in the first place was unfortunate, and that in itself was a breach. But however, the granting of land to Waitangi Māori does not give them the opportunity to later exercise kaitiaki over their traditional lands. The granting to other iwi, it does not change their position. However, it would make it harder to later be able to to get redress. Although the settlement, the treaty settlement has already concluded, rights of first refusal and such, potentially allowed them to get this land back. And also the way that Māori do not view land in the same way that Western cultures do. It is not just a matter of who owns the land, but it's more as having usage rights and having ancestral ties to the land. So granting land to iwi that do not have these ancestral ties, regardless of whether it changes their position, is inconsistent with tikanga and the principles of the treaty, which is to act in good faith and to have partnership.
Thank you.
So if I could go on to address submissions made by opposing counsel. In a response to your Honour's question, my learned friend on opposing counsel submitted that Raukawa iwi has made a full and final settlement of their treaty claims against the Crown, and therefore Pohokane cannot be returned to them. I did just touch upon this, but I would find that I would contend that finding a concluded settlement is all that needs to be taken into account can be likened to saying that procedural law trumps tikanga. It would be unfortunate if the courts were to contend that this is as far as tikanga needs to be considered. As I mentioned in my earlier submission, tikanga is increasingly recognised in the common law and is at least a source for the development of common law. My learned friend also submitted that the parties can come together after the fact. However, it is not up to the Waitangi Tribunal to hear issues regarding treaty breach. It is up to the Waitangi Tribunal to hear issues relating to treaty breaches and take into account all parties affected in accordance with tikanga. If parties must then go on to settle grievances among themselves, would this not defeat the purpose for which the tribunal was created? Your Honours, I will now go on to conclude both my and senior counsel's submissions, if there are no further questions. In summary of our submissions, firstly, the tribunal's preliminary decision sets out to inform the parties involved of what they can expect, and so is a judicially reviewable proposed exercise of statutory power. Secondly, this calls for the courts to consider whether the tribunal had correctly interpreted the resumption powers conferred on it by Section 8A of the Treaty of Waitangi Act 1975, which when read in the light of broader context and purpose needs to be consistent with treaty principles. And thirdly, the inconsistency of the tribunal's recommendation with the principles of the Treaty of Waitangi and Tikanga Māori was unlawful, as the tribunal is required to uphold the values of tikanga and the treaty. Further, a new contemporary breach of the treaty is created as the interests of Ngāti Raukawa were not adequately considered. And this concludes our submission.
Thank you.
Thank you, Ms. Sean. Judge Beck, Judge Whare, do you have any further questions?
None from me, thank you.
None from me.
Thank you, Ms. Sean, for your submissions, and thank you to all counsel. I understand that the other judges and I are now going to retire to another Zoom conference room where we will deliberate in terms of the moot.
Thank you everyone for waiting, and sorry about the little technical difficulty we had at the start. I will pass it over to the judges to tell us the results.
Great, all right. So first of all, thank you to the mooters for choosing this moot and for the submissions that you made. In terms of how we're going to do this, I'm going to provide, tell you who the best team is and who the best oralist is, and then we're also going to give you feedback to each of the mooters. So the best team was the appellants, and the best oralist was Ms. Zhang. So in terms of feedback, and obviously my colleagues will add to this, and I'll start with Ms. Zhang. The feedback that I would like to give you is that we found your presentation very engaging, that your presentation of your arguments was very clear and concise, and your ability to respond to the questions and perhaps move away from your prepared submissions was also very clear and on point. So we found that's the feedback that I would give you. Mr. Fu, we felt that you had the probably the most difficult set of submissions to make, but that you did so in a way that addressed the questions that we were answering, but also provided further context. So we appreciated that on some points you conceded that there were difficulties in what you were asking the court to do, but that your reasoning behind your submissions was nice and clear. So that's the feedback I would give to you. Shall I continue, or would my colleagues like, yep, I'm okay. For Mr. Lamb, just get that out of the way. Your submissions, thank you. We felt that your submissions were clear. However, perhaps some of the responses to some of the questions needed a little bit of refinement, and not always referring back to your written submissions was something that it's just a skill that perhaps needs to be worked on. But your overall presentation was clear and your submissions were persuasive. And finally to Ms. Sean, again, nice and clear, measured response, good tone in how you presented, but also the same feedback in relation to not necessarily that you didn't answer the question, but I guess just having some confidence in your ability to answer. It's absolutely fine to take a pause and to gather yourself. So I think that's just a matter of practice and skill, but we were also very impressed with your ability to answer the questions and also the submissions that you made. My colleagues have anything to add?
What I would say in relation to all of you is that you had clearly prepared incredibly well. You really did understand the arguments that you were making, and not just the particular arguments, but the information and the case law that sat in behind it. And that was apparent in the way in which you answered questions. And that's always really important, because judges aren't always going to ask you what you think they will. And Judge Armstrong, you know, gave you quite a good run for your money on a whole lot of those questions. But you showed that you really did understand what it was that you were arguing. That the thing you've got to be prepared to do is believe in your preparation. So make sure you've done that preparation, and then when you're answering the question, don't go back to your subs, listen to the judge and answer the question from what you know. And I think Ms. Zhang, you gave a very good example of that, and also all of you did it quite very well, but I suppose you're the most persuasive when you don't have to look at your paperwork, when you can look the judge in the eye, know that you know what you're talking about, and actually persuade and argue. That's what advocacy is about, and that's probably what just slightly pushed the appellants ahead of the respondents. So it was a close run thing. You all did really good work, but it was in the answering of the questions that where the slight point of difference lay, and it wasn't easy for us.
Sorry, could I just clarify, actually, because this is our first time doing it. So is it a bad practice to, when asked the question, point to my written submissions? Is that less persuasive? Is that what I'm getting, or am I interpreting this wrongly?
There's nothing wrong with it. The judge will always read your submissions, and they'll go back and read them later too. What you're better to do is show that you know your submissions, and you might say, I do cover that later, Your Honour, in section 4, paragraph 4. However, look them in the eye and answer it. It's far more persuasive than flicking through your pages and getting to that paragraph and then reading it to them. It may well be that you cover it, and what that means is when you get to that later on in your subs, you don't cover it again. Because you've already done it, you've done your job, move on. So yeah, that's what I'd say there. Because you guys all knew your stuff, you really knew your stuff, and you didn't need to go back and check what you'd written, because you could have just answered it.
Yeah, thank you. Yeah, that clarifies it.
I just want to echo the comments of, sorry, Judge Beck, did you have further comments?
No, I was just handing over.
Oh, okay. I just want to echo the comments of my judges, my fellow judges. This was an incredibly difficult problem for you in terms of what you had to address. These issues challenge senior counsel, and they also challenge the courts. So they're not easy issues to deal with, but taking that into account, you all did incredibly well. So I want to acknowledge and congratulate all of you on both the written submissions and the oral submissions you presented, because you really did do an excellent job dealing with both a very difficult set of facts and also a very difficult set of legal principles that you had to consider and apply. I didn't think there was much between the two teams. As my fellow judges have said, what edged it for us is that counsel for the appellants were perhaps a little bit more direct and clear in the way in which they responded to the questions than counsel for the respondents. And I'll clarify that in terms of some of the individual feedback I have for each of you. So Ms. Zhang, we were very impressed in particular with the way that you responded to the questions. It was clear that you were able to step aside from your written submissions. You listened carefully to the questions that were asked, and you were able to respond in a very clear and comprehensive way to the question that was asked, and we were really impressed with that. I was also impressed during the course of making appearances that you made an appearance both in Te Reo Māori and in English. That was also, I thought, very good, and I was very impressed with that. Mr. Fu, as noted, you had a very difficult issue to address, but I thought you did it well. And again, there wasn't much between you and Ms. Zhang in terms of the way in which you responded. Ms. Zhang probably edged you a little bit in that she demonstrated she had an ability to respond to all of the questions. I think there was one that I may have put to you where it caused you to pause and you were able to respond it eventually, but it took you a little bit of a circuitous route to get there before you developed your thoughts and were able to respond in a more confident way. And that's probably what I thought was the difference between the two of you, but you did an excellent job. Mr. Lamb, in terms of some individual feedback for you, now, again, in terms of the questions you were asked, as my fellow judges have said, the ability to answer the questions clearly and directly is a real key skill in terms of engaging with the judge and presenting a compelling argument. Now, you did answer the questions and you got there, but your approach of referring back to the written submission, the only reason that detracted a little bit is because the written submission wasn't directly focused towards the question. So it meant it took you had to cover a little bit more groundwork, working your way through the written submission before you finally moved on to answer the question. So you certainly got there. And so I certainly want to commend you for that. But it's one of the advantages of being able to listen to the question and respond to it without referring to the written submission is it means you can focus your answer perhaps a little bit more. So I would perhaps give you some feedback on that to try and further develop your mooting skills. Ms. Sean, again, the tikanga questions were clearly difficult questions, but I thought you did very well. I thought you had a very clear understanding of the relevant background in terms of both the impact that the Crown breaches had had on all of the relevant iwi, including Wairarapa Māori, Raukawa and Tuwharetoa. And I thought you did an excellent job there. Again, just following on from what Judge Beck said, there was one question I think that I may have asked. I think it was on whether the status of Raukawa and Tuwharetoa as tangata whenua had been preserved. That was perhaps a little bit, again, of an example of where it took you a little while to develop your thoughts, but you got there and you answered the question well. And what Judge Beck had raised, and I think Tracey Whare had raised as well, there isn't anything wrong with perhaps pausing and just taking a little bit of time to develop your thoughts before you respond. And again, that's just something that you can perhaps work on because it will allow you to, when you deliver your answer, to do it in a more considered way rather than stepping through the thought process during the course of your answer. But congratulations, everyone. You did an excellent job.
One other thing I thought that you all did well was make appropriate concessions when you needed to, and acknowledge at times when elements of your argument, and this applied to both sides, were sort of unattractive. That is actually always very important to do. And as long as you can go, listen, this is an unattractive argument, but, or the outcome might be unattractive, but this is the reason why it's the right thing to do. I think you all did that really well, and that's something a lot of lawyers really struggle to do, and all four of you did that well right from the outset, so congratulations on that.
I support Judge Beck's comments. It's also a very important way to get the judge on your side, because if you take a reasonable approach and make reasonable concessions where they're due, the judge will immediately think that you're not just advocating a hard line, and that you are taking a reasoned and well-considered approach. It's not to me, that's not to say that you should make concessions where they're not due, but none of you did that. You did it where it was reasonable and where it actually enhanced and strengthened your submission. So, well done.
Thank you to all the judges. It's really great to have such comprehensive feedback, and I think it's really helpful for all of us, even us watching, to develop our own advocacy skills as well as the mooters involved. So we really, really appreciate your expertise and your wisdom there. We just want to also thank Tracey, Judge Beck and Judge Armstrong for giving up your time tonight. I know that it's hard in level 4 lockdown to get on to Zoom, and it's a lot harder than potentially in person as well. So we really, really appreciate your time. And again, your expertise and your wisdom here. We want to thank the competitors tonight for preparing so well, and again, congratulations to our winners tonight. It has been great being able to collaborate with the University of Auckland, and I hope this moot can continue in the years to come. Thanks again to Tracey for writing a question with an issue so important for New Zealand law students to consider. We hope everyone at home has found value in watching this moot, and we hope you all continue to keep safe in lockdown. And if you have any questions about this moot or our mooting societies or our upcoming moots, please get in touch with the representatives from your university. We would love to have more people involved in mooting, and love to have people getting more experience in their advocacy skills before they leave law school and get into the legal profession. So without further ado, if anyone has anything else to say, you're more than welcome. Or we'll end the competition here. Perfect. Thank you, everyone, and have a good evening.
Thank you.
Thank you, everyone.
Thank you so much.
Thank you, everyone.
Thank you. Bye-bye.